Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing Thai wills. So for those who are unaware, yes, it is possible to have a will drafted in Thailand. For most folks, especially many of our clients, we oftentimes have it drafted in both Thai and English just to sort of cover all bases. The will can operate in multiple jurisdictions. Some folks choose to have a will specifically for Thailand, which only operates with regard to assets and bequests to be made in Thailand. So that's something to be aware of. Now, what are we talking about when we're talking about a residuary? Well, in any kind of will, you can have what's called a residuary or residual clause, wherein, and this can happen a lot, times may change, there may not be specific provisions made to property which is acquired later after a will is created. And again, depending on the facts of a case, it may be possible to kind of have a catch-all provision or a residuary, a residual provision in the actual document, which provides for the specific bequest as well as anything that wasn't mentioned or wasn't thought of or didn't exist at the time that the will was drafted. Now, if you make major changes with respect to your assets, with respect to your estate, it's probably a good idea to go ahead and either redraft a will or have a new codicil written and just sort of tacked onto the old will. In either case, again, it's something to think about, the fact that one's estate can change over time. A residuary, though, a residual clause, which basically states, look, anything that's not mentioned specifically in here, I'm going to go ahead and give that to this person or these people, whatever. Now, in an American context, you may have a residuary which essentially pours over into a trust. Thailand doesn't have trusts, so the residuary issue is not so much designed to pour into a trust. But it may not be a bad idea, sort of as a backstop, especially if there's only one beneficiary or proposed beneficiary, or one person somebody's thinking of, but there may be other possible legal heirs when it's not spoken to in a testamentary instrument. So what I'm saying here is, there may be property out there that's not mentioned in a will, and there may be other heirs out there that aren't specifically mentioned in a will, and where there's silence, it could lead to a situation where the court takes over and says, look, this is what we're going to do. And that may not be what the deceased actually wants to or would have wanted to occur. In those cases, a residuary clause, basically something that sort of a catch-all, that can be very useful in preventing an issue where bequests can be made or inheritances can be conveyed that the person who's basically the person whose property it was wouldn't really want that to happen.